For example, if you're going to put an offer, get as much as information from the seller agent regarding is a hot water rent is rental. Ask them to provide some proof. If sometimes furnaces are also rental, and we tend to believe furnaces are not rental. There could be air condition which could be rental. Okay, so make sure we try to get as much as information on that, because when the client goes to buy a house, they see furnace there, and they would assume furnace is already included in the price. And it's just generally ask probing questions. Uh, other mistakes, I would say, more common, I would say, um, depending upon the agreement. Like most of the time, we take care of the mistakes. Make sure we put condition that house is left on room clean condition, and make by the final visit on the last day, so you have everything in compliance. And on final visit, for example, I'm just giving examples. For example, you go for final visit, you find something is not working, or something is missing, which uh, as a buyer agent or your client think it was owned in the house. So don't leave that issue open. Try to immediately speak to the listing agent and say, listen, I came to your final visit, we have this thing missing right now. And try to create a record of how it's going to be fixed. Okay? Because as a lawyer, once it comes to us, it increases inefficiencies, because you want to get closing done. You don't want to leave it open. And if you come to me, I will write to another lawyer. Other lawyer, we don't. If it's not in writing, it does not exist. Okay, keep that in mind. If, for example, if the door is broken, you go there, or window is broken. So either try to get it fixed or get credit and put a record. Okay, for example, if the window is broken, you can say the seller undertake to fix the window and agrees to hold $500, and that 500 will be released on when the confirmation of window has been done. Because what is happening sometime, again, what would happen otherwise, buyer agent will write to me, for example, Sukhi, the window is broken, and I will write to other lawyer will say, okay, I'll tell my client, and we are going in cycles. If I tell the other lawyer, you can you hold $500, he will say, if it's not in writing, I will not hold. Same for me also. If I'm selling lawyer, I would not hold any money. So the misconception that you can hold money is, unless it's in writing, you cannot hold. You have to complete the deal in escrow. So and ask question. I think if it's more common sense approach. If you find anything, ask your broker, ask your colleague, and ask your lawyer. And even if that lawyer is not working, client has another lawyer, you might have your own lawyer. You can reach out to your own lawyer, and there's no reluctance. Like uh, you want to get the smooth closing done. So if I answered your questions, yeah. So put it in writing, and mostly we see problems with the chattels, rentals, those things.
Thank you, Mr. Sukhi. Thanks for the answer. And there is another question. Uh, the market was very hot last year, even in the beginning of this year, and we were not doing any inspections. There was no inspection clause in the agreements. And
Yeah.
suppose, like, there is no inspection, and uh, like something is broken in the house, like which are the latent defects which we couldn't see. So how to cover that? How to deal with that?
So I think ORIA cover this in their courses. So if something is visible and could have been seen by due diligence of the realtor, that will not be covered. Okay. But for example, if there is a mold and it's visible, and you put the offer, okay, and later on say, oh, there was a leakage in the house, we don't want to buy, you're stuck. Okay. But if there is no board, and you go into the house, and later on you find out there's a mold. The closing has already been done. Okay, hypothetically.
Yes.
There will be only two things you could do. Lawyer can write a letter to the seller lawyer and say, listen, my client just moved in, we found this is a problem. Could you ask the seller to fix? And if seller fix, that's fine. If does not fix, unfortunately, the only option would be small claim court.
All right. Sounds good. And another question, is it advisable to note down the serial number of the appliances when like we buy the house, or put it in the agreement?
Okay, there's no requirement per se, but it's always advisable. More information is good, but at least take the pictures. If in inventory you can't find you can't find serial number, after you put the offer, when you first visit, make a video of everything, because listing agent will only show the good things in the house. Okay, and then you can take a picture, and then you can make sure it's there. Yeah, you can put serial number, but at some point of time you will start realizing the benefit between efficiency and requirement. Most of the transaction, I would say all of them work on faith. There's element of faith. There's element of trust. This whole market, the way the whole thing is structured it's on the trust. Yeah, but it's a good idea to get. If it also depends upon your client. If you find client, if wife is very picky and she's going after appliances, and that's the central point for the wife, then maybe it's a good idea. It's a judgment call.
Right. Thank you very much. And there is another question that when we put an offer for a condo, and there is a element which is called status certificate. So what exactly that is, and why it's important for the buyer?
Okay. Again, I believe Oriya covered this thing in your courses. Whenever there is a common area element which are to be maintained by more than one person or co-owned by more than one owner, the law in Ontario require there has to be a condominium corporation, and there has to be board of directors. Their job would be to regulate and maintain the common area, which would include the elevators, the roof, the outside parking, common area sprinklers, fire retardants, or all those things. So status certificate will give you the overview of two things. First, if your client is in default, if the seller is in default of the payment, number one. Number two, it will show the reserve funds, because law of Ontario requires reserve funds in place. Of course, if elevator is broken, then it's going to cost hundreds and thousands of dollars. And there will be financial audit which is required, and it will show the financial audit, even the last audit is done. If there's special assessment being done, also status certificate will show, for example, in a building, there's a slip and fall. So the person is going to sue the building. So any litigation which is ongoing against the condominium corporation, that will be shown. So it's information which would assist the buyer to make a decision. Okay, and also the lender. Keep in mind, there are few buildings in Brampton for which the lenders don't give any mortgage at all. So that is something that's not a part of the status certificate, but the status certificate gives you all the information which is required under the Condominium Act. It is legally required, mandated by the province of Ontario.
Right. Thank you. And there is another question, that what is title search and when it should be done? Number one. Number two, as the buyer is covered by title insurance cover anyways, and the other insurance he buys, so why it is done?
So title search is the search of the registry office document, which will show is there any owner who's a rightful owner. It will show any right of ways. It will also show any existing liens on the property. Okay, so any previous owner mortgage on the property, or someone has bought a furnace and the furnace guy has put the lien on the property. All those should be seen. And why title search has to be done? Otherwise, how would you know the real owner in the registry office? So title search has to be done. Now, the question is, when you're buying a title insurance, why we need to do the title search? Okay, you cannot buy title insurance without searches, put it this way.
Okay.
Because when you buy title insurance, you have to tell the insurance company, these are the problems right now, and if there's any problem we are aware of, and then we will have to disclose to the client. Okay. Title insurance, I think I can cover title insurance more comprehensive over here.
Sure.
People ask why to buy title insurance. Okay, I will give you an example. For example, Ritesh has a property over here, and he's during winter he goes to Florida, and it is rented property. Okay,
right.
Ritesh will not be coming to say Brampton for 6 months. Okay, and I know that. So I can collude with someone and create a Ritesh ID and his wife's ID, and unbeknown to Ritesh, we can sell the house. This can happen. This has happened few times in Ontario. It rarely happens. So title insurance will cover any fraud on the part of the seller. So buyer is buying in a good faith, okay, for consideration, and a buyer cannot be blamed. So if I sell Ritesh property to say Neeraj, okay, and when Neeraj moves in, Neeraj will think, oh, I bought the property, but Ritesh doesn't know property has been sold. In March, Ritesh come to Brampton and say, oh, Neeraj is sitting over here. So there's a ID has been forged, would have been forged and house been sold. That's a classic example of where title insurance will cover. Number one, title insurance will also cover if there is any outstanding taxes which has not been paid by the seller, or any hydro bill or electricity bill. Okay, and insurance will also cover some of the faults or errors on part of lawyer. For example, I sold Ritesh property, and for some reason I missed to discharge the mortgage, which generally does not happen. Like 99.99999% will not happen, but for 0.001%. So title insurance will cover that also. And more importantly, title insurance, no bank lends the money without title insurance place, because the bank would have invested the money in the property. Ritesh would only put probably 25 or 30%. The bank money is at the stake. So bank will not lend the money without title insurance. So these are the coverages, and that's the mandatory requirement.
But in Ontario, the title insurance is not mandatory.
No, it's not mandatory by law, but if I'm a bank, okay, if Ritesh, you're buying a property and I'm putting the money, I would ask for it, because my money, bank's money, bank will not lend the money. So there's no law that it is mandatory. Yeah, and I hardly believe any lawyer will suggest to close the property without title insurance. What happens later on if there's a defect in the property or someone sold by forged IDs?
Right.
Okay. Yeah.
Yeah, makes sense. And let's come back to the today's market. When the appraisals are coming very low, like suppose I bought the property in like a couple of months ago, and today when I got when the closing is to be done, and the lender asks for appraisal, and the appraisal is coming low, and the buyers are unable to close the transaction in few cases, of course, and what can we do to prevent such situation?
Get appraisal before you put an offer. That's one solution.
Okay. Yeah.
So we can look at this way.
Right.
Once deal is firm, it's firm deal. Okay, and buyer should not and cannot walk out legally.
Mhm.
It's a breaching a contract. Contract is a contract. It's a binding contract. Hypothetically, for example, if Ritesh bought a property for 1.5 million, and two things can happen. Either three things can happen. First, either market can go up or stay same or go down. Only three things can happen.
That's
Okay.
right.
If market goes up and I bought it, I'm only going to pay 1.5 million because contract is a contract.
True.
Okay. And if market goes down, then also they should get 1.5 million because if now coming back to appraisal, that is a risk the buyers take. You know, uh, it is an intersection of market force and legal issues which come and collide over here. Legally, we have to complete the transaction. I'm not sure as a lawyer or as a realtor you could do about the markets. Only thing is try to put condition, try to get pre-approvals. Before qualify client properly. Because end of the day, uh, we all, including the client, the seller, the buyer, the mortgage, everyone want to close the deal. It's in everyone's interest to close the deal. Now, hypothetically, if buyer walks away, okay, what can happen? So there's under the law, the deposit will be forfeited immediately. But the
Mhm.
but forfeiture, the problem happens. For example, the money sitting in trust account of the brokerage. Now, brokerage will not release that funds without court orders. Okay, but okay, so that's one aspect. And if the seller lists the house and sells it at a lower price, they can come get the damages against the buyer. We had few deals. We have probably from last 2 months, we have 6 to 7 deals in which either buyer or seller walked away, and we have
Mhm.
created opinion letter advising client, do not walk away. These are the consequences, but it's their call end of the day. You know, yeah. But your question, can we do anything about it? I'm not sure we can control the market. This is a turbulent market. This is part of the business. Just
Right.
minimize the risk.
Perfect. And one more question: that what are the common problems which hinder the smooth closing? Like, uh, uh, like what are the usually you encounter?
So the most prevalent number one problem would be late arrival of mortgage instructions. You know,
Right.
uh, clients don't have mortgage, or they have been told by a mortgage broker or the bank that mortgage is coming, it's on the way, and that last month something comes up, they need more paper, they didn't accept this, they didn't accept that, and right didn't accept that. So mortgage uh, is number one problem on the day of closing. If we don't have mortgage instructions, of course, we will not be able to close unless there's another way of getting the money, either cash or private funds or something. Okay, number one problem would be that. Uh, Rest of the problems are manageable. Like if I have not seen any deal falling through uh, when we have money in our trust account.
Mhm.
We will create something, we'll work out something, we'll create a bridge, we'll create solutions to the problems. But it is good to, as a matter of practice, it's good to minimize the problem. How you minimize it? Uh, uh, Put your title search date 2 weeks on an average before the closing date. Reason being, if we find some defect on the property, we can cure it. Okay, try to 15 days are good enough time. Get your lawyer early, like say at least a month before, and let the client communicate with the lawyer and build a trust with the lawyer. And leave it to the lawyer uh, and set up a reasonable expectation of the client. You know, uh, uh, any client when it's very important for real estate professionals or anyone who's a professional to set reasonable expectation. Nothing is free in this world, you know. So uh, setting a reasonable expectation that lawyer fees would be whatever. Like, don't go for the so if a client calls me and he starts saying, okay, how much will you charge? I say $1,200. Oh, there are other people who charge $999. My first reaction is, sir, it is possible. Like our level is different. We try to cure it. That's how I deal with it. No, but that gives us a sense that whether we even retain this client is worth or not. You know, so set up a reasonable expectation, open communication with the lawyer, and uh, I think the rest everything we can take care of. As long as you guys send us mortgage instructions time, we guarantee closing will be done.
Okay, perfect. So you said that mortgage instructions on time. So what is the latest when a lawyer should receive the instructions to close the transaction the same day? So like what time? Like you should receive it around 9 o'clock in the morning or
No,
10 a.m.
so no, it doesn't work this way.
Okay.
So let's put an example. Today is August 6th. You get into agreement purchase and sale. Closing will be most likely 60 days to 90 days from today. So August, September, October, say October, November. Okay. Immediately your client will start getting mortgage. The mortgage will be approved. Generally speaking, they should have approval. We get mortgage instructions sometime 15 days before closing, sometime 2 days before closing. If you're telling us when we should get mortgage instruction, ideally we should get 3 to 4 days before closing. But what is happening is we had been recently seeing a late arrival of mortgage. For example, the closing is on Monday, and we are getting mortgage instruction on Friday or sometime Monday. Okay, it creates a lot of pressure on lawyer to run around because how it works. Let me explain you. The bank sends us a mortgage instruction on portals. We have like online portals. Okay, it comes out into a portal, and bank doesn't send us money. They send us instructions. Based on instructions, we generate documents, which will include mortgage commitment, and all those things. We will send the request for fund to the bank after that, and then bank will release the money. Okay, and
right.
Yeah, so it's not that sometimes we hear that people think mortgage instruction coming is money is coming with instructions. No, and they have to sign the paperwork and then send that. It also depends upon type of banks you have, whether it's a broker deal or it's a bank deal. So
right.
All A-class banks, RBC, TD, Scotia, CIBC, BMO, all those A-class banks, they invariably, if it's a direct deal, they will fund within say 24 hours. Okay.
Right.
But some of the banks or some of the broker deals which come to us, for example, Equitable Bank, Home Trust, and there's other trust companies. They ask for and then get the funds. So I would recommend if you have a client who's buying, get them qualify for mortgage and send instructions as soon as possible to the lawyer. So on closing day we are not running around. It gets stressful, and our job is to get smooth closing. Happy client, repeat client. Yeah.
Right. Thank you. And another question is, as you said that there are online portals from where you can get the fund, like the instructions and everything. And there is the registry or the registration of the property. It is online as well. That's
yes,
what.
right.
Yes. So why we need to do the closing on Monday to Friday? And why can't we do it on the statutory holidays or maybe weekends?
Okay. So registry office of course, registry office is opening hours online is for registration purpose. Like that. Okay. So the registry office work on Teranet. Okay, this portal, that's a separate portal. In Teranet, there are two timing limits. One is doing searches. You can, for example, I can do searches right now. Okay, but any change of ownership, any change in date, that can only happen between working day between 8:30 a.m. 5 p.m. 5:01, the online portal for registration is stopped. Okay, so that is the reason we can only register properties. It's just like, I don't know how many people here understand. Tahsildar is only sitting there until 5. Okay, if that makes sense, you know.
Right.
Yeah, the stamping of the deed, the creation of the deed can happen. Deed is like ownership, or deed is also about mortgages. It can only happen until 5 on working days. So that's the reason.
Perfect. One question you already answered, and I'm going to get to the next question. And do you advise us to put any special clauses on the APS, either it's for condo or it's for a freehold property or a vacant land? So
for residential, you're talking about residential. Okay, yeah, because
I'm talking about residential right now.
Yeah, see, again, keep your eyes open, have some common sense approach, you know, and every property is different, every client is different, you know. But generally speaking, some clauses are very standard. Okay, first clause is that the money will be paid by certified check through a very large transaction. I think you guys have that word.
Right.
That's always there, you know. And other than that, I would recommend putting clauses, for example, the seller certified that this property has never been used for drug, you know, to their knowledge, drug grow-ups or anything. Leave it in room condition, and you can put conditions, for example, financing, of course, financing and inspection, and sometime if it's properties. You guys deal with the power of sale properties? No.
Yes, we do.
Okay. So power of sale property, you can't put much conditions. You know, it's worked differently. I'm not going to deal with that right now. So, so these are the conditions, and again, it's very specific to the buyer. You know, if buyer is qualified and you're putting bully offer, I would still want some of the conditions to put, like for example, the drug. It has never been used as a grow up. The seller will live in broom clean condition. If they have a copy of survey, ask for survey, you know, and if there is any credit to be given, put it in agreement, you know, don't verbally talk. For example, you find again, you say you go for inspection, you conditionally deal is done with conditions of inspection, and you go with inspection, and inspector find that roof has certain problem or windows have certain problem. Put it in the agreement, make an amendment. Okay, set a reasonable expectation of client and put it in writing. If it's $500 worth of credit, put the seller agree to give $500 credit for the window. Okay, and I think the rest of the stuff, I think brokers can assist in condition. I think ORIA has a lot of conditions they apply. One thing I would want to touch is about spousal consent. You know, I think we hear a lot about spousal consent. Under the law, you need spousal consent only if it's a matrimonial home. You know, I know some certain brokerages has practice always get spousal consent. Just there's no issue about it. But under the law, if the house which is being sold is a matrimonial house, you know, and matrimonial house is where designated as matrimonial home, then you need the seller need to get the spousal consent, otherwise not. You know. Okay, so I think that's pretty much I would say, you
Right.
know, yeah. But like another thing is Ritesh, call me, call your any other lawyer. Early you communicate, better it is. Sometimes it's good to call lawyer before even you ask for offer. If you find something and you're not clear, first reach out to your broker, because that's a broker are there to help you. But if still something comes up and you can always ask for lawyer opinion on the phone, like we have this situation arising. I think a lot of problems can be solved dealing with upfront, because we want a smooth closing.
Right. Thank you. And I'm going to ask the just one more question, and then we'll leave the field open for all our realtors so that they can ask any questions if they have.
Sure.
And what is the difference between the closing of a residential property, like you touched that we are discussing the residential, or the commercial property? So is there any major differences in the closings?
Yes, there's a fundamental difference between residential and commercial. Now, commercial can be many different things. Commercial can be buying a pizza store, buying a shop, buying a franchise, buying a lot of other stuff. So, residentials, uh, we have to realize when is a residential closing and it's in part of subdivision. Lot of due diligence has already been done. City has a record. When the subdivision is built up, a lot of stuff is already taken care and factored into the registry office. Okay. In commercial, for example, if you're buying, for example, you're buying a plaza. Okay. Now, in businesses, invariably corporations get involved. They're not personally owned. Okay.
Right.
Even if it's personally owned, there will be lot many things, environmental and all the things comes in. Let's talk about two different examples. One, for example, you buy a pizza store. It goes under bulk sale act. It doesn't go under registry office. We don't do registry office searches on pizza stores. Okay, so we will have to do the searches, bankruptcy searches. We have to do PPSA searches. We have to do the RIT searches. We have to see any inventory. We have to zoning compliance. We have to see if the pizza store is allowed to be opening, zoning compliance. We probably will end up checking a fire order from the city, because it's a public place, you know. So fire, if there's any fire order breach, and if it's OLG, for example, someone selling regulated stuff, for example, lottery. So you have to get the permission of those people. So it's entirely different ball game. Okay. If it's LLBO, then you have to see if the liquor license was properly held, if there is any breach, because if there's a breach, the LLBO will not be transferred to the buyer, you know. So that's a pizza and eating place. But if it's a commercial property, for example, you're buying a shop, then it's kind of mixed. We will have to do registry office searches on the shop because it's in registry office, but we also have to do PPSA searches if it's any guarantees being given, any bankruptcy being done, and maybe if it's auto shop, we might have to do environmental compliance. So they're a bit different. Yes, fundamentally different.
All right. Thank you very much. And we have a realtor, Aman. She has got one question. So,
Sure.
Aman ji, can you ask him?
Good morning. How are you, sir?
I am good, Aman. How can I help you?
Yeah, I have a small question. If there is a property
Yes.
and at some point, like in the beginning, it was matrimonial home, and later it got converted to rental investment.
Uh-huh.
So, do we still need the spousal consent?
Okay. So on the date of selling, that's where it falls to. If on the date of selling it's a matrimonial home, you need it. If from the seller, if on the date of selling it's not a matrimonial home, you don't need spousal consent. But again, if you can get it, that issue is not will not even arise.
Okay. All right. Thank you, sir.
Yeah.
All right, thanks a lot. And any other question from the team?
Morning, Sukhiji. My name is Vic, and I really appreciate your time this morning. Always good to have a legal perspective, you know. So, and you were a rare combo, right? I had so many friends in engineering, you know, went on to do MBA financing, but yeah, engineering and legal lawyer, you know, it's a rare combo. So hats off to you and your skill sets. Yeah, I just have a small question. Like, what are the rights of tenants during the selling process? And this question is for residential as well as commercial. So I know commercial, they have long lease periods, you know, and residential, most of the people, you know, they have basements rented. So what are the legal rights for the tenants, you know, during the selling process?
Okay, so let's give a hypothetical example. If there's a house and in a basement there's a tenant, okay, and it's residential. If it's residential and there's a residential tenant, then Residential Tenancy Act will apply. Okay, the moment Residential Tenancy Act applies, all the rights of tenant which is offered by Residential Tenancy Act comes into play. Okay, so now it does not matter whether basement is legal or not. Let's be clear. The landlord tenant board will not care about that. That's not their prerogative. They are only there to apply tenants act and landlord responsibility. How I'm going to answer this question now? The best way to avoid any tenant problem is, if you're selling, speak to tenant and get I think it's N9 or N11 form.
N11, yes.
Agreement to terminate the tenancy, have it signed.
Right.
Okay, so or there are options. If the buyer is buying a property for their principal residence, then they have right to get the tenant out. But that does not itself solve the problem, because if tenant is not out by the closing date, the buyer will have to bring an application in landlord tenant board. So best way to deal with is convince the tenant to get out. That's the right, you know. The leases have to be assumed unless the landlord or the new owner give a proper reason and go to the landlord tenant board and get the tenant evicted. Okay, so it could be sometimes very messy. Again, you want to give me specific question, like this is a very generic question, specific situation like this happened and what can be done, you know, maybe I can direct on that way.
Yeah, no, it was indeed a generic question, but what you're trying to say is it will be the new buyer's responsibility, right? If they don't vacate, or will it be the seller's responsibility to give them a clean house?
No, okay, here's the thing. So it will depend upon what's in the agreement. Okay, if you are representing a buyer, for example, Vic, you're representing a buyer and there's a tenant in the house which your client want to buy, I would strongly recommend you to put a clause that the seller will give the vacant position and tenant out of the property on the closing day or before closing day.
Okay.
Then it becomes their responsibility.
Sure.
Okay, and if they don't comply with it, then you are stuck, you know, like the clarity of the clauses is very important, you know.
Sure.
The moment you see tenant, it should raise red flag in your head, you know, like, listen, do you have solution or you want to look for another property? You know, if you're selling, then and you want to list the house, you know, and you have a good listing coming for $1.5 million and you want, like, okay, I want to get listing as a tenant, Speak to the or seller and see what they have. Do they have lease in writing? Okay. Again, keep in mind, there's no need for written lease. Written lease will only clarify.
Sorry, we lost you.
Okay.
We lost you for a quick second, right?
Okay. Okay. I will repeat it. Okay. So if you are selling a house, if
Okay.
you're getting a listing for there's a tenant, either in basement or upstairs. Okay.
Yep.
Speak to the seller, see whether they can have the tenant vacate the property.
Okay.
Tell the seller, if there's a tenant,
Yep.
the chances of you getting offer are substantially reduced.
Okay.
Chances of getting the price
Yeah.
is substantially reduced. That will motivate the seller to get the tenant out.
Okay.
Okay. What we have done many times, I have done this few times. This is a creative solution, you know. For example, Vic comes to me and say, I'm getting this listing and there's a tenant, you know, Sukhi, how can we get this tenant out?
Yeah.
What I would say is that make a written agreement between seller and the tenant,
Yep.
signed by both and witness,
Yep.
and which will say seller, the tenant will vacate the property on September 1st or on or before closing date, which is N9.
Okay.
That's the first step. If the seller, if the tenant is not agreeable, now the tenancy, this guy will give me some money to get now, you know. So I have done what I have done is I have suggested realtor, okay, you know, make an agreement in which between seller and tenant, on which the seller will write, I hereby agree to give $2,000 check 2 days before closing and on tenant vacating the property.
Okay.
So
Sure.
so that's the incentive you give for tenant to move out.
Sure.
That for business purpose, get the tenant out.
Okay. Great.
Resignation.
So these are like amicable solutions, right? You know, what is the legal route though?
So here's the thing: if you listed a property and you listed it and the buyer bought it, you have to get vacant property.
Yeah.
Then you have to give vacant property. Then seller will have to sue the tenant, go after tenant, and get it vacated. If I'm buyer lawyer, I will tell my client not to get this property.
Okay.
Yeah, like I will say like, no, I will not sit down to get the property. I will say, wait until the tenant is vacated the property to close. Extend the closing. We will never say don't buy the property. We'll say, until you have a solution, this headache is gone, don't close it.
Okay, great.
Yeah.
And these are like common things you see day in, day out, or rare case scenarios?
Like one closing in 2-3 months, which have this kind of issue, you know. But being proactive again, like end of the day, we are here to serve a client. Their interest is better served, and our interest is better served. If we can handle this kind of problem upfront.
Okay, sounds good.
Yeah.
Great. I appreciate your reply. Thank you very much.
No problem.
Thanks, Vic. And
thanks.
Anybody else in the team who has got questions?
Yes, sir. I have one more question.
Sorry. Yeah, go ahead.
Yes, Aman.
Sir, when it's an investment property and the other person, the buyer is assuming the tenant, right?
Okay.
So now, like, you know, I've seen a couple of times it says like, you know, we are getting vacant property, but then we get the lease and, you know, other kind of documents. But what is the right way to handle it for an investment?
So if it's an investment property, for example, your client has a investment property in Waterloo and it's tenanted. Okay. And if you're selling and tenant is going to stay there, you know, you can list on MLS. Here's the tenant pay $1,800 per month. You know, the buyer will have to assume the tenancy. Okay, that's number one. I think that's solved the problem, because the buyer will know that, and buyer is also buying investment property. He will not have to find new tenant. That's a selling point. Like, listen, you just buy, close, and then you have $1,800 coming into your account, which is paying your mortgage. And property is increasing in value. Did I answer your question? I don't know.
Yes, sir.
Yeah. So it depends. It depends upon the situation. If you have a buyer who want to buy a property, and this is how you set the deal. Actually, you sell it. Okay, I have investment property. We also have a good tenant. Why don't you buy a property? You don't have to look for tenant. We will check credit for the tenant and we'll assume tenancy. If it's a good tenant. If like, I own properties and I have tenants, everyone would have here, but unless it's a bad tenant, it is always good, and for bad tenant, the best thing from business point of view, to avoid any legal problem. Though I'm a lawyer, you are here to do business end of the day. You don't want into legal mess. You don't want your client into legal mess. So avoid any legal problem and have a creative solution. For creative solution, call me. I will give you any input I can.
Right. Thank you, sir.
Yeah.
Thanks, Aman, and thanks, Mr. Sukhi. Is there any other question from the team? Because I know Mr. Sukhi has got a meeting at 12 o'clock, so we have just a couple of more minutes. If there is any question. I guess there is not. And thank you very much, Mr. Sukhi. And thanks for your time and valuable and informative information. So thanks a lot.
You're always welcome. And again, try to deal with the problem upfront, rather than lingering on. Put everything in writing in real estate. Ask your broker, ask colleague, I think you will have all the solutions around you. Thank you. Good luck.
All right. Thanks a lot. And have a wonderful weekend. And talk to you soon.
Bye.
All right, guys.
Thank you very much.
Have a wonderful weekend.
Thanks.
Thank you, sir. Thanks, everyone.
Bye.
Have a good weekend.